anniversary of Godzilla. Now, this panel is brought to you by the Legal Geeks podcast, which is hosted by the great Joshua Gilliland. Give a round of applause for us. The Legal Geeks is a podcast that looks at all the nerdy stuff that we love through the prism of the legal system. It's kind of like jury duty, but with one case. Now, without any further delay, I would like to introduce our legal panel. Attorneys assemble! Please welcome to our panel U.S. Magistrate Judge Stacie Beckerman. Get this, grandnephew of King Kong creator Merian Cooper, Monte Cooper. Deputy City Attorney for the City of San Diego, Kathy Steinman. U.S. Courts Bethany Bengfort. And Legal Geeks' own Joshua Gilliland. One more time. Now let's destroy all previous legal theories. First off, this is a question that I have always had after watching any and every Godzilla. Who pays for the Acts of Godzilla?
Tokyo, sometimes Boston, sometimes San Francisco.
As long as it's not Minya, because that kid's got enough troubles. All right, who wants to take this one? Kathy.
Got this one. So this is actually a good law school exam question, which would take about 3 hours to answer, and I can give it about 2 minutes, so bear with me. So first we have to think about what are the costs that we're talking about. And they kind of fall into a couple of categories. The first would be your first responders, who's actually responding to the emergency. So with respect to police, fire, paramedics, those things are usually going to be covered by local and state government, which would be paid by the taxpayers, which would be you all. Thank you for your hotel tax spending here, by the way. If it were the military that were responding, that would be the state or the federal government, most likely the federal government. Again, taxpayers, thank you. The second cost that we're talking about, I think, which is what most people are thinking about, is the damage, right? Who pays for the damage to all of the property that happens from these battles? So then we have to get into, well, what's the type of damage that we're talking about? The property damage, but there are also injuries, perhaps even deaths that occur, correct? So when we talk about property, the first question we're going to ask is who owns the property? And again, that's going to fall into about two categories. First, we have private property, and then we have public property. When we're talking about private property, what we're looking at are private buildings, cars, personal property. In those instances, the costs are probably going to be borne by the property owner themselves. They may have insurance that may or may not cover kaiju damage. I'm sure there's probably some exclusion in there, so you would have to read your homeowner's policy carefully. Another question would be, what about FEMA? If this is declared a natural or a disaster or a state of emergency, there might be federal funds available to assist those people to help rebuild. And then the third question we can think about, and this is what lawyers always think about, is did someone else cause it? Can we sue somebody for it? And so that would depend on the facts of the case. Did somebody do something to lead Godzilla to cause the damage? And so if you can make a nexus, we call it proximate cause in the legal arena, if you can make that nexus, you might be able to recover or sue a third party and recover some of your costs from them. When we're talking about public property, what we're thinking about are things like streets, lampposts, traffic signals, government buildings, things like that. The infrastructure for your city or your town. those costs are probably going to be borne by the government itself, whatever agency it is, whatever public entity it is. So again, it's the taxpayers. Some governments and public entities are insured by they purchase insurance policies, so there might be some insurance money out there that would be available to them to recover. Again, FEMA could be another resource, especially also because if a state of emergency is declared, what's important about that is that it not only does it open up access to funding, but it also opens up access to other resources such as military and things like that, or other emergency aid that you can get. And then again, did somebody else cause the damage? Can we sue somebody to recover? And then we get to the injuries and death. So if there is somebody who is injured or dies because of an attack, most likely we look first to see, do they have some sort of insurance, health or life insurance that could cover this. If they don't, then possibly the injured party themselves would have to pay unless they have single payer health care. Unless we do. I won't go there. But the other thing could be, doctors take a Hippocratic oath. So, if there's this cataclysmic event and there's a flood of people going to the emergency rooms, they have to treat these people. They're not going to turn them away. And then as they are, later on, they're trying to figure out who they can recover the money from. If a person is not insured or something like that, the healthcare providers often will write off the costs that it took to care for these people during these kinds of events, and they end up getting a tax deduction for that. It's like basically a charitable donation for them. So that is another way. And then again, can we sue somebody? So that's kind of the quick answer.
Wow. I think we can all agree, get Godzilla insurance. Yes?
Yes.
All right. Next up, you saw this device at work in the original 1954 Gojira and in the latest film, Godzilla, King of the Monsters. Tell us, Monty, is the oxygen destroyer a weapon of mass destruction, and why is everyone so mad at oxygen?
All right. Take these one at a time, and I'll start with a point. If there's any proof that the panel is sympathetic to the composition is going to die in the next movie, they just gave me the biggest softball of all the questions. First of all, let me ask the audience. It doesn't matter if you have a law degree. Does anybody here think the oxygen destroyer, and think about the name of the thing, is not a weapon of mass destruction? If you are going on an FBI watch list immediately.
It is not a weapon of mass destruction. It's a weapon of area denial. It does not destroy structures. It takes away oxygen so you don't go there.
A biological weapon doesn't destroy structures. It's a weapon of mass
Which is also not a weapon of mass destruction. It's
Now, let's take a look at the laws.
Alright, save it for the back alley, okay?
All right. The definition of a weapon of mass destruction, it actually, in all fairness to the audience, it actually is deliberately not in most countries a definition that has been defined by law, because international law in the wake of World War II wanted to have maximum ability to define it by the circumstances. As you might guess, the fact that we had the bombing of Dresden, we had the atomic bomb, we had chemical warfare, all these were known in the 40s and the 50s, and there was a recognition that as science advanced, that we would have difficulty in always defining what is in fact a weapon that can kill a massive number of people. In the wake of 9/11, a whole debate arose about whether or not weapons that were devices that were otherwise benign, like planes, could be weapons of mass destruction, as they clearly could be in light of what happened in New York. As a result, one of the few countries that has actually attempted to define a weapon of mass destruction is in fact the United States. And if you look at the definition that exists in the criminal code, it's pretty benign, or I shouldn't say benign, because whatever weapon of mass destruction is, it's not benign. It's actually relatively, surprisingly, just a bomb can be a weapon of mass destruction, as if you think about it, depending on the context, a bomb can kill anywhere between 1 and thousands of people, depending on how it's manipulated. The oxygen destroyer was described by its original progenitor, Dr. Sakazawa, in the original Godzilla film as such a destructive device that if it were exploded above ground, it would destroy Tokyo. Again, that is mass destruction. He, as a result, commits suicide to ensure the rest of the world does not get access to this device. That tells you how sincerely powerful it is intended to be by its progenitor. In the most recent movie, it creates a green mushroom cloud, usually a sign of a weapon of mass destruction. And I will cede this to the next topic. In the 1990s movie again, Godzilla vs. Destroyer, it creates an entirely new kaiju. If that isn't a weapon of mass destruction, nothing is. And with that, we go on to the next topic.
Spoiler alert. In the 1995 film Godzilla vs. Destroyer, the oxygen destroyer creates Destroyer. Honestly, what can't that thing do? It's really a wonder. Bethany, what is the toxic tort liability for the creation of Destroyer?
Well, I'm glad you...
why didn't they just name him Destroyer?
Oh, well, because you don't say destroyer, you say destroyer, right? Like that. I believe that's the correct Japanese pronunciation.
Yes.
Anyway, so this is a very interesting question. So normally you use toxic torts for things like asbestos or Agent Orange or something where you're kind of directly exposed to a chemical substance. Whereas here you have the microoxygen that's gone into the soil and then has mutated these prehistoric crustaceans into this big giant kaiju named Destroyer. And now that kaiju is going around and killing everybody. And so the question is the person who released this chemical responsible for all the havoc that Destroyer, this is gonna get old real fast, but caused? So there are typically 4 elements when you're talking about a toxic tort. The first question is the substance dangerous? The substance we're talking about being microoxygen. Now, I initially thought this was a slam dunk, but man in the red shirt, is there a counter argument to the substance being dangerous? All right. Okay, everybody agrees that microoxygen is dangerous, yes?
Yes.
All right. So the second question is, was the plaintiff, the person who's suing, exposed to the substance? Now this is a little bit harder because technically the plaintiff has been exposed to something else that was exposed to the substance, right? So the plaintiff is not being exposed to microoxygen, they're being exposed to a giant kaiju monster. So I think most lawyers would try to argue that there is still this causal connection between microoxygen and then the injury to the plaintiff, right? But for the release of microoxygen, this person would not have been injured. This kaiju wouldn't have been created, and so there's a direct causal link that they would try to establish. And that's the same sort of thing with, did the substance cause harm to the plaintiff, right? You have the same type of arguments. No, the substance did not directly cause harm to the plaintiff. The big giant monster did. But then, you try to establish that causal link there in order to sue somebody, because, that's what we do. And the final question being, did the person who is handling the microoxygen use the appropriate standard of care in their handling of the microoxygen, right? And this is an interesting question. I mean, as we mentioned before, we had a scientist who was so adamant that this weapon should never, ever be used, even if giant kaiju were all over the world, that he actually committed suicide in order to prevent the release of this technology everywhere. So he clearly had very strong feelings on the matter. But But I will say generally, in an emergency situation, we have different views of what the standard of care should be, right? And so this was certainly an emergency situation. You had a kaiju monster who was going around killing bunches of people, and then, somebody made the decision. Now, normally there's lots of, the appropriate standard of care requires, a lot of testing of the substance, a lot of, careful thought and deliberation, maybe some warning signs, please be careful, oxygen destroyer in use, that sort of thing. But there just wasn't time for that, and I think the ultimate question would be, knowing the risks of this thing, was killing Godzilla the appropriate action there? And so I think this would be a very interesting case. So I would take it. I would take Godzilla's side, though, probably. Yeah.
You got it.
Yeah.
All right. No, you can call it. All right. Josh, for some reason, Godzilla tends to also bring out human monsters.
He does.
Yeah. In 1966...
Lawyers.
In Horror of the Deep, also known as Godzilla versus the Sea Monster, a lot of trouble is caused by an evil organization known as Red Bamboo, which is also the name of Tahiti's most infamous driver's ed film. All right.
Objection.
Yes, it is. The question is, what international laws did Red Bamboo violate?
So many. So Red Bamboo, and this Godzilla movie specifically, is the time that Godzilla decided to make a Bond movie. And because you look at the sets where Red Bamboo is making nuclear weapons to sell to other countries, it's like right out of a Bond movie. And which is why I asked Mark Tavares over there to do this amazing artwork and go see his booth.
Mark Tavares.
And when King Kong escapes, we don't quite know their exact status. Are they terrorist groups? Is this just a bunch of fascists who have an air force? Or are they funded by a government? And that answer's never answered, or question's never answered, because we never find out. And I don't know if that was because the writers just didn't want to address, hey, let's make Red China the bad guy. They don't come out and say that, but we have Red Bamboo, we have a smashing eye patch with a design on it, and they control a sea monster, which whenever a boat goes by, or ship, or aircraft, this thing comes out of the water and smashes it. Well, that raises the issue of freedom of the seas. It's this right that all international, all nations have to be able to go to sea. And if we have a monster that comes out of the water and violates the freedom of the seas, that's one thing that they've done that's very, very bad, and we'd probably go bomb them. But there's something else that they've done. They're horrible human beings. They're enslaving people from Infant Island, home of Mothra, who's taking a nap, and they torture the people that they enslave. Throw in proliferation of nuclear weapons, these people are on nobody's Christmas card list because they are all very bad. So again, Godzilla plays Bond and smashes the terrorists who are making nuclear weapons, who've enslaved people, and Mothra comes along and flies everyone away to safety, because that's how we roll in the Godzilla movie, which is a lot like Never Say Never Again. With again, the good guys are flown away after the boat with the fin that looks like it's out of a Bond movie is sunk. So it's very funky, but I love it.
I think that would have been a better movie, by the way, with Godzilla.
Oh, absolutely.
Never Say Never Again. Judge Stacie Beckerman. In the 2000 film Godzilla vs. Megaguirus, a black hole shooting weapon called the Dimension Tide caused all kinds of problems. Was that?
Not ominous at all.
No. Nothing destroyed destroyer in there. But it causes a lot of problems, and it also creates megahertz. So, Your Honor, did the black hole weapon violate Japan's constitution?
So the Dimension Tide actually was a satellite-based weapon that was designed to shoot miniature black holes at people. Genius, right? And hats off to whoever came up with that idea. And I bring it to Washington, D.C. next time. The goal of the weapon is to swallow up whoever's in the path and basically keep them prisoner forever. And so the goal is to shoot the black hole weapon at Godzilla and swallow him up and keep him as a prisoner. The question for the day is, does that violate Japan's constitution? The current constitution of Japan was developed after World War II. It's referred to as the Peace Constitution, and it's known for Article 9, in which Japan renounced its right to wage war. In light of that goal, the Constitution forbids Japan from maintaining any land, sea, or air forces, and it bans anything that has, quote, war potential. So by show of hands, who believes that the black hole weapon designed to trap an enemy for life violates the Peace Constitution? All right, plot twist. The Supreme Court of Japan has ruled that the country may maintain weapons for defensive purposes, but it's not allowed to develop offensive weapons. And so the court hereby rules that the Dimension Tide does not violate Japan's constitution, although it's quite clearly designed as a weapon. It was designed as a defensive weapon. In the event that Godzilla comes back, it would protect the people of Japan by trapping Godzilla in the black hole forever. Clearly, self-defense for the country of Japan. So that is my ruling. So
So be it.
use that for the exclusive line.
Kathy, in the 1973 film Godzilla vs. Megalon, the underwater civilization of Seatopia is known for their humane dolphin shows and their gigantic beetle cyborg dog known as Megalon. Fed up with all the surface world's nuclear testing, they sent Megalon to destroy us. What could have been Seatopia's remedies short of going to war with the surface world?
So first I'm going to go with the non-legal options, which I think would be better suited for this. Diplomacy. You know, diplomacy is always something that we should try first. It's what we teach our kids, right? Perhaps, you know, all I'm saying is give peace a chance. You know, the second option, protest, media exposure. That's really, really working these days. You know, get your voice out there, get it heard. Get a hashtag trending, right? Don't Seatopia. Start a change.org petition. These are all things that they could be doing that are peaceful alternatives. You know, the next option could, you know, if they're really, really concerned about this, is go to court and seek a temporary restraining order or a preliminary injunction. And to do that, what they would have to show is that they were likely to succeed on the merits. That means that they are likely to win the case, that they are likely to suffer irreparable harm in the absence of some sort of preliminary relief or early relief, which would be, I think, easily established in this case that they're already suffering harm because of all of this underwater or this testing. And it's irreparable, I'm sure. Then the next thing that they have to show, and the next two kind of go together, that the balance of the equities tip in their favor, and that an injunction is in the public interest. I think they can clearly show that it would be better for them to have a preliminary injunction to stop this testing, and that it would be in the public interest not to decimate another species, country, whatever their jurisdiction is. So I think that they would be likely to prevail and at least get a temporary restraining order, preliminary injunction, but they really should try some peaceful alternatives to begin with. Not that court is not peaceful, but it's you know, it can be, they call litigation for a reason.
It would also be helpful to know that they exist. So, because the United States and other countries doing the nuclear testing didn't know they existed, which makes our bad. You know, sorry, won't do that again. But I think that's something very important to go like, hey, we predate you, look at our togas.
Toga party always helps.
I know, again, Emperor Antonio, rock on to you, proud of that chest hair. But they need to know, we need to know they exist before they just go to war with us.
They should also show off Megalon. Like, we got Megalon, just to let you know. So, let's talk. Give C's a chance. Okay. Monty, as the great grandnephew of the great Merian Cooper and a trailblazer in kaiju law, tackle this one. In 1962's King Kong vs. Godzilla, Mr. Taco, after has Kong captured as part of a marketing campaign for his pharmaceutical company, because nothing makes one OxyContin more than an angry giant gorilla. And now, let's remember, Mr. Taco was ordered by the Japanese Coast Guard not to bring Kong into Japan. What is Mr. Taco's legal liability?
Man, I thought the Octopus Destroyer was a softball, but man, this one takes the cake. What isn't Mr. Taco-san's liability? Let's start with the fact that you are ordered by your government not to bring in an exotic animal into your country, and you go ahead and do so, and you do so weaponizing it. And also, you are specifically instructed not to use munitions, and you go ahead and tell the two people that are going to capture Kong to go ahead and use weapons because, you know, the Japanese government doesn't matter. You're really looking at a lawyer's dream here before Kong gets to Tokyo. This is such an easy question that I am, in a moment, going to cede it to my panelists, because I actually had to struggle to come up with reasons that Mr. Taco-san was not liable. And I can, much like the Avengers movie, come up with one in 1 million scenarios where he's not. But let me explain the many different ways that the law was violated, whether you look at it from a US or a Japanese standpoint. One of the oldest principles in law, going back to the Romans, we're going pre-medieval, is that importing an exotic animal is strict liability. Importing a 300-foot gorilla into a municipality is a really, really strict liability. Guess what? You know, we have lots of, anybody here who's ever gone out of the country knows that you sign all sorts of customs duties. Japan has the same sort of restriction. You do not get to bring in exotic biological agents, especially ones that can kill. And you are supposed to go through a whole series of inspections, which of course, in this case, they put King Kong to sleep, and he wakes up right as he gets to the customs agents, and then on top of everything else, he aggravates an entirely different kaiju. So, and on top of everything else, let's just go back to the real point. You know, this was supposed to be about a pharmaceutical marketing project. Bringing Kong in as something that's good for the country is really false advertising, and it's not anything else. So I am putting this out to my panel, because I have one theory, and I will come back to it, but I can't even come up with ideas how he's not liable. Let's go with the judge. Let's go with the judge.
Self-defense.
Respondeat superior, baby.
All right. Stowaway. Kong was a stowaway.
Oh, we have a candidate.
We have temporary
money. All right. It's not bad. My theory is, if any of you have seen the movie, Kong and Godzilla do play a rudimentary game of baseball, in which Kong shows that he's actually a very good switch hitter, and Godzilla shows he's a very good switch hitter, and Kong shows he's a lousy pitcher. My theory is the best defense is that Kong and Godzilla were both invited to sports figures. And on top of that, I point out that in the most recent film, Godzilla wastes Fenway Park, showing that he is actually a candidate for the Yankees.
All right.
One last thing. I've been asked to point out, because of my relationship, that one thing that shows you that Godzilla also feels sorry for the Kong side of the family is that he wastes San Francisco, as you all know. He leaves 4 buildings intact, and it shows you how much respect he has for lawyers, because my law firm is one of those 4 buildings.
Good clean up. Oh. All right, man, that was a tour de force. In 1968's Kaiju Palooza film Destroy All Monsters, the all-female alien race known as the Killax take control of the Earth's monsters as well as the mind of Dr. Kyoko Yamamabe. The good doctor goes on to make mischief, but returns to normal after her boyfriend tears part of her ear off. Does the insanity defense apply to Dr. Yamabe for being under Killac mind control?
All right, well, that was a pretty tough act to follow. I will say that pretty much every disaster movie ever where I live in DC is completely crushed, so. Okay, so insanity defense. There are a lot of different types of insanity defense that different states use, and actually, does anybody live in Idaho, Kansas, Montana, or Utah? Any of those 4 states? All right, you guys do not get an insanity defense, I'm sorry. Yeah. All right.
Is that because it's proof by observation that you live in those states you are insane?
I mean,
We're not going there.
that would explain why they don't permit the insanity defense.
Don't turn into a mom.
So by way of example, with the insanity defense, you generally have things that fall into 2 buckets. So you have one that's the irresistible impulse test, which basically says that because of a mental disease or defect, I couldn't control myself. I felt this irresistible impulse and I just couldn't stop it. And that's my defense for doing this action, is that I had an impulse I couldn't control. Now, the other main insanity defense is more like, I didn't understand the nature and wrongfulness of my actions. So I had control over my actions, but I didn't understand that they were wrong. Whereas the irresistible impulse, it doesn't matter if you understand what you're doing is wrong if you can't control yourself. So it's kind of 2 sides of the same coin here. Now, Dr. Yamabe here, we don't really know what's going on in her head when she's under the Kilak's control. It doesn't seem like she understands that what she's doing is wrong, because when she attacks people, when she's addressing her brother and all of that, she doesn't seem to have any sense of guilt or any sense of attachment to her brother, anything like that. You don't know if she has an impulse she's trying to resist. You don't know if she thinks what she's doing is wrong, if she's trapped inside her brain somewhere and sees what she's doing but can't stop it. You really, based on the video evidence, you don't know any of that. As her lawyer, what I would do instead is I would argue a concept, a very seldom used defense called automatism, which is basically like, you were unconscious. You weren't there when this action happened. And this really has only come up in the sleepwalking context, where people are like, I murdered that person while I was sleepwalking. I was literally unconscious while this happened when I did this action. So you can see why it's very seldom used, but I think in this case, in this case, I think it would actually apply.
Ambient defense.
Yes, the ambient
ambient
defense.
defense.
Yeah, I was on ambient.
All right. Stacie, in the 2002 film Godzilla against Mechagodzilla, the Japan Self-Defense Forces built a cyborg version of Godzilla using the original Godzilla skeleton, because that's how cyborgs are made. Was it desecration of a corpse to build Mechagodzilla from the bones of Godzilla?
No.
Okay, moving on. Questions? No.
California law in most states have these corpse desecration statutes. They only apply to humans. So they only apply, you can't mess with human remains, you can't dig them up, you can't make arts and crafts out of human bones. But they don't apply to Godzilla. As much as we may love him and believe him to be human-like, and he might be smarter than many humans we know, the corpse desecration statutes do not apply. But let's dig a little bit deeper. Can you do whatever you want to with animal bones you find at the side of the road or at the bottom of an ocean, which is what happened in Mechagodzilla? And there's a couple of laws that apply. One is there's a bunch of laws that apply with what you can do with your pet animal corpses when they die. So if you have a pet dog or a pet lizard, you can sometimes bury those in your backyard, you sometimes can't. There's laws about that. There's also the Endangered Species Act, which would prohibit the taking of any part of an endangered or threatened species, including its bones, if it's listed on the Endangered Species Act list. Right now, Godzillasaurus is not listed. Or for the true nerds in the room, basal theropods are not listed on the list. So, Godzilla's bones are not protected under the Endangered Species Act. There's also laws about what you can do with roadkill that you find at the side of a road or at the bottom of an ocean. Know that under current California law, you cannot collect roadkill at the side of the road and take it home for dinner. But there is a bill pending right now in the California legislature that would allow you to, if you kill it, you may grill it. So keep an eye out for that. It's already legal in Oregon where I live. So. But of course, we don't want to eat the meat off of Godzilla's bones. We want to take those bones and transplant them into a killer cyborg. That triggers a whole other set of laws about xenotransplantation, of taking a part of one species and putting it into another species, such as a pig heart valve into a human. The FDA regulates that right now, it's allowed, but you have to be careful because in the movie, the Mechagodzilla who had the original Godzilla's bones actually remembered the humans killing the original Godzilla, and then he went on a rampage, so the bones always remember. So there is really no law that restricts you from using Godzilla's bones, so have at it, and long live the king.
Okay, thank you, Monty. One of my favorite films that feature Godzilla is Godzilla vs. Hedorah, or Godzilla vs. the Smog Monster. And as you all know, Hedorah is a creature that's a blend of alien meteorite-affected pollution and created this creature. And if you watch this movie, by the way, and don't come away singing "Save the Earth," something inside you is done. But are companies that cause pollution financially liable for Hedorah cleanup costs?
Oh my God, if ever appeared in Southern California, he'd be a lawyer's dream. I'd be handing out my business card left and right. See that thing? Kaiju lawyer right here? I will sue it to death. In the United States, there's a variety of environmental laws called, for instance, Comprehensive Environmental Resource Liability Act, as that long name suggests, makes you liable for the cleanup costs, as you probably have heard in more vernacular terms, Superfund. No matter how small your contribution is, you are known as jointly and severably liable, meaning that you contributed 22 ounces of cesium to that Superfund site. Yes, you are liable for $1.2 billion. Yes, it's a great law. From a lawyer standpoint, make more of them. There's also a variety of other environmental laws, for instance, called the Resource Conservation Liability Act and others, RCRA, In the United States, there'd be no question. There'd be absolutely no question to be liable. In Japan, it becomes a little more vague, and I will conclude this very quickly, but to say that the Japanese law isn't as absolute in terms of strict liability as the United States. However, as any advanced country with concerns about environmentalism, you might suspect they do have the same sort of liability requirements in place, and including some, for instance, for bad smells, which, you take a look at the smog monster, that's pretty obvious. The same with Godzilla, actually. But the answer is an unequivocal yes.
All right.
So the other question in this is, what about being compensated for your exposure to these chemical things?
Massive class action suit.
So what I'm going to do is I'm going to actually analogize to a ongoing lawsuit that is occurring. Does anyone remember the earthquake that happened in Japan in 2011? And then what the Fukushima reactor leaked? And the U.S. had military ships that were in the area. They sent several ships, including the USS Reagan, which was based out of San Diego at the time, to provide aid. And several months and continuing, a lot of those sailors actually have come down with a lot of radiation-related illnesses. Several of them have passed away. They sued the Tokyo Electric Power Company, which was the company that owns that reactor, in federal court in San Diego. And they also sued General Electric. In March of this year, that case was actually dismissed because what is important is where did the exposure, where did the accident occur? And this occurred in Japan. And so the court had to weigh whether or not California law should apply or Japanese law should apply. And the court, in its decision in this past March, said, well, both jurisdictions have a strong interest in their laws applying, but Japan had a stronger interest because that's where the incident occurred, and so the plaintiffs should be suing in Japan and seek their remedies under Japanese law. That case actually has been appealed to the Ninth Circuit. It's ongoing, so we will see what happens there. But really what's important is where did this happen, and those laws should apply.
All right. So now it's time for the lightning round. Judge Beckerman, is Dr. Emma Russell guilty of child endangerment?
If you've seen the movie, I know what you're thinking. Of course, Emma Russell is guilty of child endangerment. She allowed eco-terrorists to kidnap her and her 12-year-old daughter Madison. She intentionally waited King Ghidorah, who was up the killing spree, etc., etc. The list is up there. I'm a former federal prosecutor. I would take that case. It seems like an easy win. Give me 30 seconds to try to convince you otherwise. I'm going to do my quick 30-second impression of a criminal defense lawyer or so. Ladies and gentlemen of the jury, the San Francisco District Attorney has filed 65 charges of child endangerment against my client, Dr. Emma Russell. But my client is not some three-headed monster. And I would like to return a verdict of not guilty for at least 3 reasons. First, the alleged crimes occurred in Monarch Outpost in China, Antarctica, a Mexican volcano, and Fenway's Green Monster. This court does not have jurisdiction. The crimes did not occur in California, and the case must be dismissed immediately. Second, I think we all agree that the children are our future. And as parents, we are stewards of the earth so that we may save it from sure climactic change for our children, for the children. When Alan Jonah was looking for people to help him save the earth, guess who stepped up? Dr. Emma Russell. Not because she's a bad person on a delusional killing frenzy, but because she loves her daughter. It's for the children. Say it with me, everybody. For the children. Dr. Emma Russell's acts were justified because the planet surely faced certain extinction, so she is an eco-shero, and you should come back with a not guilty verdict. Finally, one more reason. At the end of the day, and at the end of the movie, Dr. Emma Russell sacrificed herself to save her daughter and to save all of us from King Gita has 3 creepy heads. So you can't prosecute her as a district attorney because she's dead. Monster and Mollis, ladies and gentlemen, Dr. Emma Russell is not one of them. You must return a verdict of not guilty. The defense rests.
Go to jail, go straight to jail.
All right, Kathy. Would San Francisco have been condemned after the events that happened in Godzilla 2014?
Duh.
That's enough answer, right?
Yes, it probably would be, and there are a couple of laws that would allow them to do that. And under the federal law, it would be the 5th and the 14th Amendment. We call it the Takings Clause. All of those who are the lawyers in the room remember that property. Under California law, it's Article 1, Section 19 of the California Constitution, which says private property may be taken or damaged for a public use, and only when just compensation determined by a jury has first been paid to the owner. And so basically you can take property, but you have to pay the owner the value of what it's worth. However, there is an exception for the exercise of police power. You don't have to pay compensation if it's essential to safeguard public health, safety, or morals. And so I think there's a good argument to say that given the extent of the destruction in the Bay Area, that it is necessary for public safety to take the property without compensation so that they can clean it up and then rebuild and probably sell it to a bunch of dot-commers.
All right, Bethany. Can Dr. Ishiro Sarazawa be arrested for contempt of Congress after walking out of a Senate hearing?
Well, this is a very interesting question and kind of topical given recent news events, but in the movie, Dr. Sarazawa is in a Senate hearing. The Senate hearing is about whether the U.S. military should take control of Monarch, and an emergency happens, and he kind of stands up and walks out, and all the senators are like, wait, you can't do that. So the question is, can he? Well, the first thing is, it's not entirely clear what kind of structure Monarch actually is, whether it's a paramilitary organization, whether it's kind of an international NGO. They've got a lot of outposts in foreign countries, whether it's some sort of alliance like NATO, and this would matter, of course. Now, given that the US military is holding a hearing on whether that or not they should take it under control, I think it's safe to assume that it's related to the US somehow, right? And so, maybe let's say that it's a department of the executive branch like NASA or anything, and they just want to put the military in control of it. So then, you can't. So the U.S. Supreme Court ruled in 1917 that Congress does in fact have the power to issue subpoenas to people. Normally, people were used to subpoenas coming from the judicial branch, so courts and everything like that, but they said that is, in virtue of the grant of legislative authority, there is a power implied to deal with contempt. And ever since then, Congress has had the power to issue these subpoenas. Now the question becomes, what happens when somebody violates a subpoena or refuses to answer or refuses to show up? So, legal experts have kind of outlined 3 things that Congress can do in this situation. The first thing is that Congress can go to the Department of Justice and say, hey, this person's violating the subpoena. The Department of Justice can thereafter issue a fine of up to $1,000 and then detain them for up to a year. So if you go through the DOJ and the executive branch, that's one way to do it. The second way to do it is to go to a court and say, hey, this person is violating a subpoena, and then the court will rule on whether or not the person has to follow the subpoena, and then there can be penalties if they don't after a court order. Now, the third way, and the kind of weirdest way, is that, obviously there could be political reasons why you wouldn't want to go to another branch, either the executive or judicial, to enforce the subpoena. Congress actually potentially has the power to just do it themselves, to call the sergeant at arms and say, hey, we're arresting you for contempt of Congress. Now, there's a bunch of issues with it doing it this way. the first issue is being, I'm not sure Congress has a place to put people that they're detaining. I don't know if they can like just shove them in a janitor's closet. I feel like that would be like, you know, some sort of violation. But also that it hasn't been constitutionally tested what the due process requirements would be for that kind of thing. And so I think that would very much be a last resort. The other thing about it potentially being an executive agency is that they could then declare that they have executive privilege as the reason for not following the subpoena. So essentially, what executive privilege says is that, you know, there is a compelling reason why answering these questions would interfere with my duties as an executive. So they could say, you know, these are very strong national security concerns, which, by the way, are the only reasons like invoking executive privilege ever works, is if you like claim national security.
And that's our time.
Yeah.
Thank you so much for joining us.